Hi everybody, this is Arkady Frekhtman. I'm a New York City personal injury trial attorney, and today I want to talk to you about a $1 billion verdict. Not a million, not 10 million, not even 100 million, but a $1 billion verdict. And it happened a few years ago in Georgia. And it was a case involving an apartment complex. What essentially happened was that in Clayton County, back in May 22nd of 2018, that's when the trial occurred, there was a case where a young girl, she was only 14 years old, and she was raped by a security guard who was supposed to be protecting the building where she and a friend were attending. You know, it was an apartment building. It wasn't an apartment building like we have here in New York that's 6 stories. It was like one of those 2-story apartment buildings, and they had a few multiple units. It was actually called, I believe, Point South, the Point South buildings. And so this security guard came up to her and this male friend. They were 14, and I think he had a gun or some kind of weapon, and he told the male friend to get out of there, then grabbed her and sexually assaulted her. And it was a terrible, horrific event. And it happened back on October 12th of 2012, and she was only 14 years old. And the defendant, the person who committed this rape, was somebody named Brandon Lamar Zachary, and it was the Point South Apartments, and it happened in Jonesboro, Georgia. And so this defendant, the perpetrator, the criminal, he worked as a security guard for the apartment complex. And so what happened was the 14-year-old's mother, she sued the apartment complex, which was known as Point South Inc. She sued the property manager, which was some sort of residential group Inc. And she sued the defendant, his employer, which was the Crime Prevention Agency. I guess that's who employed this security guard. And so the property owner, as well as the management company, were both dismissed before the trial even started. It doesn't say why they were dismissed, but probably because they didn't know anything about it. This was a sudden criminal action, and they probably said, look, we didn't employ this guy. We have no privity with this guy. We have no connection with this guy. He's just employed by the security company, and we need security at our apartment complex, but we have no connection with this guy. So it got dismissed as to them. But the case proceeded against Crime Prevention Agency only. And what they alleged, what they said that their contentions, what they were basically their claims, what they said that the defendants did wrong was that, number one, the security company failed in its duty to properly supervise and or monitor the officer when the incident occurred. And so at the time of the incident, like we talked about, she was attending a birthday party outside at the apartment complex, and this was during daylight hours. And she and a male friend walked to a picnic table. They were approached by Zachary, who was armed. And this guy, Zachary, the perpetrator, he was only 22 years old at the time, and he had no training at all. He was not licensed to be an armed guard, but he approached them, and he was armed. And he ordered the male friend to stay, and then he began to, he grabbed the girl and began to sexually assault her. And she attempted to fight, but she was not successful. And she said that following the incident, the Zachary just walked away, and she and her friend returned to the apartment complex where the police were called. And this guy, Zachary, was arrested and charged with rape, statutory rape, and child molestation. And he was then sentenced to 20 years in prison. And so the plaintiff's lawyer argued that the security company, the Crime Prevention Agency, had knowledge of this security guard's behavior against guests and tenants of the complex, but ignored the circumstances that any reasonable person would interpret as leading to the injury. And the attorney also argued that Zachary had been hired when he was only 22 years old, no experience, and not licensed to be an armed guard. So this was like a negligent hiring and a negligent supervision. So when you're an employer, you have to do some kind of background check, especially if it's a job like a security guard that's an armed guard. You can't just hire anybody, right? You can't hire like somebody who has a criminal record or somebody who has no experience, somebody who's not licensed. So you have to do a background check. So that's negligent hiring. You have to be reasonably safe and reasonably careful when you hire someone. But there's also something known as negligent supervision. So after I hire someone, they're my employee, right? So if they do something wrong, there's something known as vicarious liability, meaning they do something wrong, but I'm their employer, so then I'm liable for them. They're like my agent, right? And also respondeat superior, because the superior responds for the employees, right? So that's how it works. Just like if you sued, let's say, for example, a driver and the vehicle is owned by Amazon, well, you could sue Amazon, right? It's the same kind of thing. But here, it's even worse because all three of them really come into play. So there's negligent hiring. You can't hire someone who's dangerous like this. There's negligent supervision. You have to supervise the worker. You can't just let the worker go out. You know, the guy has no license. He's 22 years old. And I think he's done something like this before where he either menaced somebody or assaulted somebody, and they're just letting him continue working. So they're not supervising him. And there's also something known as negligent retention, meaning once you hire him, you know, once you find out, okay, you hired him, but he's doing something bad, you could fire him, but you're retaining him. You're not firing him, you're keeping him. That's negligent retention. So negligent hiring, negligent supervision, negligent retention. That's three different causes of action. So the court actually granted summary judgment and determined that the Crime Prevention Agency was liable as a matter of law. So that means that they didn't even need to go to trial. There was no question of fact to be decided by a jury, but rather it was so clear that as a matter of law, the judge said, this Crime Prevention Agency, this security company is liable. And the case went to trial only on the issue of damages. Now, Crime Prevention Agency, the security company that employed this guy, the perpetrator, did not appear at trial and was not even represented by an attorney. So I guess they got a default judgment against them. And so those are basically the facts. Now, if we turn to the injury, we see that the girl, the 14-year-old girl, was taken to a hospital. She had a rape kit done. She was then discharged from the hospital. She came under the care of a psychotherapist where she treated for a few years. And she was diagnosed with post-traumatic stress disorder, PTSD. And I've done videos about PTSD and how it can be as valuable as a brain injury, that it's a very serious, life-changing, forever injury. And she testified about how the alleged assault impacted her life. She stated that her personality changed. She became socially withdrawn. She lost friends. And according to her, the relationship with her mother got strained, and she began to distrust authority figures, especially males, and would not feel comfortable going to the police in an emergency. And at the time of trial, she was a college sophomore majoring in social work and volunteering by helping the homeless during the summer. In seeking damages, her attorney asked the jury what the amount was that a rape victim should be awarded, and noted, compared it to like professional athletes, and they're paid hundreds of millions of dollars. So like you sign a contract for like 5 years and it's like 100 million for 5 years, right? If you're a professional athlete. So he somehow compared that to this. And the jury ended up allowing for $1 billion. So like 999 million plus one. So $1 billion. Now, whether or not she actually collected any money is, we don't know, because we don't know how much insurance, assets, or we don't know about this company. If the company did not even answer the complaint and they weren't a part of the trial, it may mean that they had no insurance. So it could be that this owner of this apartment complex just hired some fly-by-night security company that, doesn't have any insurance, and that company then, that's why the company uses a 22-year-old with no license to be an armed guard, and then that guy just goes rogue and rapes someone, and, so that it could be that they recovered nothing. We don't know. It just wasn't part of the report. I'm looking at verdict search, and I actually did a little bit of research. I looked online and Google. I Googled the company itself, the place, and it looked like it had like 2.9 stars, on Google reviews. Everyone was saying it's a terrible place to live. I even put in the word security after I Googled it to see if there were any complaints about security, But the only comment or review that I saw that mentioned security just said that there is no security. So I guess this happened at a time when there was security. Maybe now, because this was 2012, maybe now there's no security there. But so it's unclear as to whether or not this verdict was paid, and if so, how much of it was paid. And there have been articles about this case. If you Google the case, $1 billion verdict in Georgia, you'll see there have been articles. There was a New York Times article, other articles, and they basically say that, you know, she felt kind of like helpless, and she felt like downtrodden, like basically she couldn't get any justice, and like she's nobody, right? That you could be raped, you could be sexually assaulted, and then you don't matter. And now this kind of told her, no, your life does matter, you do matter. So that gave her a little bit of hope and a little bit of, you know, a little bit of positivity. But, you know, the problem is, I don't know if she collected any actual money. But I guess, and by the way, it was only a one-day trial. So the whole trial was only one day. And it's unclear from who was called. I'm assuming perhaps the psychotherapist was called, the plaintiff was called, you know, probably just the psychotherapist and the plaintiff if it was all done in only one day. But yeah, but $1 billion verdict. I think that was the first $1 billion verdict in the history of the nation. And it came down in, like I said, in 2018. So I hope this was helpful. Let us know what questions you have, and we are here for you. Our goal is helping serious injury victims and families. And let us know if we could help you. If you have a question, if you wanted to do a free confidential consult, you could always text me, 347-566-9595. And I've been scheduling chats with people and answering their questions, whether it's in New York, we could help directly, or if it's in another state like Pennsylvania, Florida, California, Kansas, wherever, you know, we've been working with the top trial attorneys in that area. What I do is I don't just pick anyone, and I definitely don't pick any billboard lawyer, but we pick lawyers that are trial lawyers, and we vet them. So there's no negligent hiring, you know, on our side. We vet them. We make sure that they are trial lawyers with multiple, many verdicts of $1 million or more, and then we, you know, we can partner with them, and then they would be primarily responsible. But if the case were to go to trial, I can come down and do the trial with them. You know, I love doing that, and I've been, you know, asked to do trials all over the country. So I may be doing trials in other jurisdictions, but and as well as New York. We just did one in New York in June, where we got a $2.2 million result, and last year we got a $3.5 million result. So we love doing trials, and we're going to continue doing that all over. Okay, everyone, have a great day. We are here for you, and all the best. Okay.